An Arizona administrative law judge obviously can't vacate part of the district court's order. Arizona's actions in this case cannot have been premature because the damage is already done if, in fact, the district court's unitary status plan exceeds its authority. And there was no mention of that in the argument you just heard. Curricula is ultimately the state's responsibility. Only the state of Arizona can command a school district to develop a particular type of curricula. Curricula is, there's some discretion about how you develop it, but it has to meet the state standards that are highly specific for each grade level. And in fact, if a district fails to do that, the state steps in, takes over the district, and does everything, including curricular development. Now, the nature of the motion below turns on the language of the court's order in disposing of it and the matters addressed there. And I just want to point out that when the district court issued its order denying what was captioned as the second motion for reconsideration, it said that it was timely in respect to the state's ability to affect the terms and provisions contained in the USP. Now, that's an analysis for a motion to intervene. It's not analysis under Local Rule 7.2 for whether there was good cause. Also, the court used language that's consistent with the denial of a motion to intervene. In fact, it specifically says at page 17 that it's denying the state's request to intervene and that it's reaffirming its decision to deny the intervention of the state of Arizona, as opposed to whether reconsideration is timely under the circumstances. Now, as for the matters addressed, the court certainly had discretion to get to the merits of the motion and address all of the Rule 24A and Sierra factors, and that's what it did. The motion argued that the unitary status plan did exceed the scope of the court's remedial authority, and I refer you to ER docket 1418 at page 4, and perhaps most importantly, the court rejected it on the merits. The court said, and I quote, "The court does not exceed its authority by approving and adopting the USP that contains the curricular provisions." And as far as Arizona's raising that point below, I just want to point the court to the parts of the record where Arizona did indeed argue that the USP was exceeding the scope of its authority in the original motion to intervene. And I'm talking about volume 4, docket 1367 at page 2. The state specifically argued that the ethnic studies and culturally relevant curricula, and I'm quoting now, unconstitutionally usurp Arizona's right to administer its laws. If you look at the state's objections to the proposed unitary status plan, and now I'm referring to excerpts volume 3, docket 1409 at page 4, the state argued that in the long history of this case, again I'm quoting, this court has made no findings that the curricula and courses offered by Tucson Unified School District violated any student's constitutional rights. The proposed remedy of creating specific courses for African American and Latino students is thus not a remedy that is required to vindicate any constitutional guarantees. And in case there's any doubt about whether this was litigated substantively below, I want to point you to one more document and note that the Mendoza plaintiffs responded robustly to this argument about the scope of the district court's authority. Excerpts of record volume 4, docket 1370, beginning at page 2, that response devotes 4 pages exclusively to the 10th Amendment argument. And finally, and most importantly, the district court addressed and rejected it in its final order, which is the order we're appealing from. The court said, and this is at page 16 of its order, which appears at volume 1 of the excerpts, quote, "The court does not exceed its authority by approving and adopting the unitary status plan containing curricular provisions." Now, if that is the issue before the court and the issue that the court ruled upon, I do not see how that issue can't be properly in front of this court. The final point is that the state's contention has been mischaracterized here today. It is not that any culturally relevant curricula would violate an Arizona statute. There are certainly types of culturally relevant courses that would conform to Arizona law. But if you design one specifically centered on the cultural experiences of African American and Latino students, then you are culturally isolating them. and you are teaching them only about one culture. And that's not merely a violation of Arizona law, that is directly contrary to what the Supreme Court was attempting to remedy in the Milliken II case. The Detroit school system had so pervasively and persistently segregated African American students in that district that they became culturally isolated. They were not part of the mainstream of students taught in that district in other schools, and it developed in them, and I'm taking all of this out of Milliken II, it developed in them attitudes, habits of speech, etc., that were outside of the environment in which they would need to compete in the post-secondary world. In this case, you have a unitary status plan that is attempting to achieve exactly the opposite. You have students who are presently in the mainstream, and you have a culturally relevant curriculum plan that specifically centers on one ethnic or racial group and teaches that group only about that culture. That is contrary not only to Arizona state law, but to United States Supreme Court precedent. Thank you.
Thank you, counsel. The next part of the case, are a separate group of lawyers?
Arizona's not a party.
All right, well,
Not yet.
we consolidated it for argument, I guess, but that part of the case is submitted.
This part is submitted.
Yes, the intervention, Arizona intervention is submitted. Now, this part, I guess, is Mendoza versus Tucson Unified School District. Counsel?
May it please the court, my name is Mick Rusing. I'm here today on behalf of the Tucson Unified School District, TUSD. Before I start, I'd like to reserve 5 minutes of my time for rebuttal. There's also a preliminary matter of a blow-up exhibit that we had prepared that I understand there was an objection to, and I was told by the clerks that there was going to be argument, if any, on it. I don't know.
Yeah, all right, you may use your exhibits.
All right, thank you, Your Honor. If you don't mind, you want to set it up here?
It might be an exhibit for younger judges. I don't have my distance glasses with me, and that's really hard to read. Could you bring it up closer, counsel?
Sure, and
I just thought these were eye tests when I saw them in the trial court. Okay. This works. Thank you.
What's that? Oh. Well, we have it in front of us, so we don't
Great.
know.
We have this.
Why don't we just take that down, because I can't see deputy clerks here, so.
okay, thank you,
This
Your
is the
Honor.
same thing, right?
Yes, Your Honor.
Okay, great. I can see this.
All right, thank you.
Even I can see it.
TUSD is doing everything it possibly can to obtain unitary status, and in order to achieve that, it must do two different things. One is to establish a good faith record of compliance with the unitary status plan that's been adopted, and number two, eliminate the vestiges of prior discrimination to the extent practicable. And we are here today to make sure we're in a position to obtain that status, but we need this court's help. And here's why. As part of this process, a unitary status plan, USP, was negotiated by the parties and the special master and was adopted by the court last year as a roadmap to obtain unitary status by the end of the 2016-2017 school year. Then prior to the USP, in 2012, the parties also negotiated and the court entered an appointment order appointing Willis Hawley as a special master under Rule 53. And one thing that the parties did in these extensive, and then the special master, did in the extensive negotiations leading up to these orders was to agree upon a methodology for objecting to the R&Rs from the special master. And this is where the board was going to come in handy, but I'll refer the court to the lower portion of the handout. Rule 53 provides that the court must give the parties notice and an opportunity to be heard before ruling on a special master's R&R, and provides 21 days for that purpose. And also it provides that facts and law will be reviewed de novo. When the parties were negotiating the appointment order, they expanded it so that the parties would have 30 days for objection and then 20 days for responses, and that would give the special master himself a chance to respond, and then 21 days for replies. And it also permitted public comment during this period. The USP, going across the chart, incorporates the judicial resolution process of this appointment order. And that's the only place in the USP where the special master order objections are dealt with. Now, everybody signed off on this very rational approach, and the court entered it both in the appointment order and by signing the USP. The problem is that's not what's been implemented by the district court. Instead, the first 3 R&Rs were adopted by the court the same day they were filed. Same day. In fact, 2 of the R&Rs were filed as attachments to the district court order adopting them. And one of these orders actually did away with any right to object to the special master's R&Rs, and that was done at the behest of the special master. So the problem we're now faced with is TUSD does not have an opportunity to object as was agreed to as set out in the handout. Secondly, there's no de novo review being conducted as required because definitionally you need an opposition to have de novo review of an opposition. Thirdly, there's no application of the correct standard of review, which includes some deference to TUSD for the plans it proposes to see if they are compliant with the Constitution and USP. Because the standard is not whatever the special master thinks it's best practice from an educational policy or opinion standpoint, but whether or not the plan initially proposed by TUSD on these various issues is constitutionally compliant. And that is not what is occurring here. And all of this is...
Let me ask you something. Am I incorrect in my impression that after you had this initial procedure that the district court modified it somewhat to say, why don't you 2 parties get together, try to work it all out before we get this recommendation? The 2 of you develop something together to the extent you can and work with the special master, and then he will submit